Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving robbery and defense, a key topic in criminal law under FLK2. Let's dive in. A man is sitting in a shopping center with a bag beside him. A woman approaches and points a screwdriver at him, saying, "Give me your bag or I'll stab you." She intends to threaten him, but the man, an expert in martial arts, does not feel fear. The woman then uses the screwdriver to lightly injure the man, grabs the bag, and runs away. The man chases her, but she drops the bag and escapes. What offenses has the woman committed? A. Robbery and assault occasioning actual bodily harm. B. Attempted robbery and assault occasioning actual bodily harm. C. Theft and common assault. D. Attempted theft and assault occasioning actual bodily harm. E. Robbery and battery. The best answer is A. Robbery and assault occasioning actual bodily harm. Under Section 8 of the Theft Act 1968, robbery occurs when a person steals, and immediately before or at the time of doing so, and in order to do so, he uses force on any person or puts or seeks to put any person in fear of being then and there subjected to force. In this case, the woman committed theft. She took the bag. She used force, lightly injuring him with a screwdriver, in order to steal. The injury was deliberate and immediately before / during the theft, satisfying the force element of robbery. So, robbery is clearly made out. In addition, the use of the screwdriver causing injury goes beyond trivial harm. This constitutes actual bodily harm (ABH) under Section 47 of the OAPA 1861, which requires A. Assault or battery, and B. Actual injury, more than transient or trifling. Scenario 2. After the woman uses a screwdriver to lightly injure the man, she grabs his bag and runs. The man chases after her and, using considerable force, pulls her down to the floor. He retrieves the bag. As a result, the woman's skin is grazed and bleeding. Did the man commit any offense? A. Yes, he committed battery by pulling her down and injuring her. B. No, because he was acting in lawful self-defense. C. No, as he used reasonable force to prevent crime and recover stolen property. D. Yes, he committed assault and the defense of crime prevention does not apply in these circumstances. E. Yes, he committed assault occasioning actual bodily harm. The best answer is C. No, as he used reasonable force to prevent crime and recover stolen property. Under Section 3(1) of the Criminal Law Act 1967, a person may use reasonable force in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders. Robbery is a continuing offense, and the force used during immediate pursuit may still fall within this exception. The question is whether his force was reasonable in the circumstances. Pulling someone down to recover stolen property after being attacked with a weapon appears proportionate and reasonable. Even though the woman sustained minor injury, this does not automatically make the force unlawful. The man did not use gratuitous violence. The use of considerable force does not invalidate the defense if proportionate to the threat. Scenario 3. The woman who committed the robbery is physically fragile. When the man pulls her to the ground in order to recover his stolen bag, her bones are broken, her skin is torn, and she later develops a serious infection. She now asks whether the man has committed any criminal offense, and whether she can bring a civil claim against him, assuming she knows his name and address. What is the correct legal position? A. The man committed assault occasioning grievous bodily harm, and the woman can bring a civil claim for damages. B. The man may be liable under the thin skull rule, and the woman may bring a civil claim for damages. C. The man used excessive force and committed battery, the woman may bring a civil claim. D. The man did not commit an offense in view of reasonable force, even if the woman was hurt more than expected. She cannot make a valid civil claim. E. The man used grossly excessive force and is liable in both criminal and civil law. The best answer is D. The man did not commit an offense in view of reasonable force, even if the woman was hurt more than expected. She cannot make a valid civil claim. The man was recovering stolen property immediately after a robbery, a continuing offense, and was therefore entitled to use reasonable force. Although the injuries suffered by the woman were severe, courts apply the thin skull rule only after liability is established. If the use of force was lawful and reasonable in the circumstances, then no criminal or civil liability arises, regardless of the extent of injury. In addition, courts will not usually allow a person who committed a violent criminal act, like robbery, to profit from injuries sustained as a result of his own unlawful conduct. These tables illustrate key principles we walked through. In Scenario 1, the woman committed robbery because she used force, screwdriver, to steal, and ABH because the injury was more than minor. In Scenario 2, the man committed no offense because he used reasonable force to recover stolen property immediately after a robbery. This is legally justified. Finally, in Scenario 3, even though the woman suffered serious injury, the man is not liable criminally or civilly if his force was reasonable. The severity of injury does not matter when the use of force is lawful. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.